I never thought my life would spiral into a full-blown legal battle with a homeowners association. But that's exactly what happened when Patricia Wilson, the self-appointed queen of Oakridge Estates, decided my front yard was her personal mission. The first warning letter arrived on a Tuesday in April. I'd been living in Oakridge Estates for nearly 4 years without issue. The neighborhood in Richardson, Texas, had seemed perfect when I bought the house. Well-maintained properties, good schools nearby, and reasonable HOA fees. At least, that's what my realtor Howard told me. What he conveniently failed to mention was that the HOA was run by the most pedantic power trippers this side of the Mississippi. Harrison Xavier, a 35-year-old software developer who mostly kept to himself, suddenly found my modest 2-story home at the center of neighborhood controversy. The letter, printed on crisp HOA letterhead, informed me that my non-conforming landscaping elements were in violation of Covenant 7.3b, and that I had 14 days to remedy the situation or face a fine of $50 per day. The so-called violation: 3 potted cacti on my front porch. I stared at the letter in disbelief before walking outside to examine the offending plants. They were small desert cacti I'd picked up at a local nursery, nothing outlandish or obtrusive. I'd placed them on my porch because they required minimal maintenance, perfect for someone like me who traveled frequently for work. After rereading the letter twice, I pulled up the HOA covenants on my laptop. I'd received a copy when I purchased the house, but, like most homeowners, had filed it away without much more than a cursory glance. Section 7.3b stated, all visible landscaping must conform to the approved vegetation list. Non-conforming plants must be approved by written request to the Architectural Control Committee. I scrolled through the approved vegetation list. Sure enough, cacti weren't on it. Neither were about 100 other common plants. The list seemed arbitrarily restrictive, favoring a limited palette of traditional suburban greenery. Rather than immediately capitulating, I decided to email the HOA board to request an exception. I drafted a polite message explaining that the cacti were drought-resistant, required minimal water, and posed no threat or eyesore to the community. I attached photos of my modest arrangement and hit send. The response came 2 days later from Patricia Wilson herself, the HOA president, whose signature adorned the original warning letter. Dear Mr. Xavier, the Architectural Control Committee has reviewed your request and denied the exception. The cacti must be removed or relocated to a non-visible location within the original 14-day compliance period. Thank you for your cooperation. No explanation. No room for discussion. Just a flat denial. I was annoyed but not yet angry enough to fight. I moved the cacti to my backyard patio and considered the matter resolved. 1 week later, another letter arrived. This one cited a violation of Covenant 8.1f, improper vehicle storage. According to the letter, my car had been parked in my driveway for more than 72 consecutive hours without moving, which apparently constituted storage rather than parking. This was bizarre for 2 reasons. First, I'd been away on a business trip for the past 5 days, so my car had been in the airport parking garage, not my driveway. Second, I didn't recall any rule about having to periodically move vehicles parked in one's own driveway. I checked the covenants again. Section 8.1f stated, no vehicle shall be stored in visible areas, including driveways. Storage is defined as remaining stationary for purposes other than day-to-day transportation. The wording was vague enough to be interpreted in multiple ways. Was leaving a car parked while on vacation considered storage? By this logic, every homeowner would need to hire someone to periodically move their cars while on vacation. This time, I called the HOA management company directly. "Hello, this is Xavier at 1742 Oakridge Lane. I've received a violation notice about vehicle storage, but I'm confused because my car wasn't even at my house during the dates in question." The receptionist transferred me to a property manager named Melissa, who sounded immediately defensive. "Mr. Xavier, violations are documented with photographic evidence. If you received a notice, then your vehicle was observed in violation of the covenant." "But that's physically impossible," I explained. "I was in Seattle for a work conference. My car was at DFW Airport." "Perhaps it was a different vehicle then," she suggested, clearly unwilling to admit an error. "I live alone. I own one car. There shouldn't be any vehicle in my driveway when I'm not home." After several minutes of circular conversation, Melissa agreed to investigate and get back to me. 3 days later, I received an email stating the violation had been rescinded due to new information. I should have been satisfied, but something about the situation left me uneasy. Had someone mistaken another house for mine? Or was I being targeted specifically? I didn't have to wait long for my answer. Just 4 days after the vehicle incident was resolved, I received a third violation notice. This time for unapproved exterior modification specifically, a doorbell camera I had installed over a year ago. This was getting ridiculous. I'd never received any complaints about the doorbell camera before, and several of my neighbors had identical models. The covenant cited 9.2a stated that all exterior modifications required prior approval, but doorbell cameras weren't explicitly mentioned, and the rules seemed to be selectively enforced. Instead of contacting the management company again, I decided to attend the next HOA board meeting scheduled for the following Tuesday evening. It was time to address this face-to-face. The meeting was held in the community clubhouse, a modest building next to the neighborhood pool. About 20 residents were scattered throughout the rows of folding chairs. At the front, a table was set up where 5 board members sat, including Patricia Wilson in the center, her silver blonde bob perfectly styled, wearing a pink cardigan despite the Texas heat. I signed in and took a seat in the back row. The meeting followed standard procedure approval of previous minutes, treasurer's report, and committee updates. Finally, they reached the open forum portion where residents could address concerns. I raised my hand and approached the microphone when called upon. "Good evening. My name is Xavier from Oakridge Lane. I'm here because I've received 3 violation notices in the past month after 4 years of no issues. The latest concerns a doorbell camera that's been installed for over a year without any previous complaints. I've noticed many other homes with similar cameras, so I'm confused about the sudden enforcement." Patricia's smile didn't reach her eyes. "Mr. Xavier, all exterior modifications require prior approval as stated in the covenants you agreed to when purchasing your home." "I understand that," I replied, "but enforcement should be consistent. If doorbell cameras require approval, then shouldn't all homeowners with them be cited? Also, I'd like to understand why I'm suddenly receiving multiple violations after years without issue." A few murmurs of agreement rippled through the audience. Patricia's smile tightened. "The board has recently implemented more thorough covenant enforcement procedures. All violations are being addressed as they're identified." "By whom?" I asked. "Who's identifying these violations?" "We have a covenant enforcement committee that conducts regular inspections," she replied, her tone growing cooler. A man in the second row raised his hand. "I've lived here 8 years and never heard of this committee. When was it formed? Patricia glanced at the other board members before responding. The committee operates under the board's authority. We don't need to announce every operational detail. The meeting grew tenser as other residents began asking similar questions. It became clear that many felt the enforcement had become arbitrarily strict in recent months. As the meeting wrapped up, I approached Patricia directly. I'd like to resolve this doorbell camera issue. Can you tell me exactly what I need to do for approval? She glanced at me with barely concealed annoyance. Submit an architectural modification form with the camera specifications and photos of the installation. The committee meets monthly to review requests. And in the meantime, you're in violation and subject to fines per the covenant enforcement policy. I took a deep breath. So even though dozens of homes have these cameras, I need to remove mine until I get approval, which could take up to a month. Those are the rules, Mr. Xavier, she said with finality, gathering her papers. On my way out, a woman approached me in the parking lot. Don't take it personally, she said. I'm Julie Davis. I live on Sycamore Drive. Harrison Xavier, I replied, shaking her hand. Has this been happening to others? Julie nodded. Patricia's been on a power trip since being elected president 6 months ago. My neighbor got fined because her trash can was visible from the street for more than 4 hours after collection. That seems excessive. It is, and selective. Her friends never seem to get violation notices, even when they're breaking the same rules. This conversation with Julie marked the beginning of my understanding that I wasn't being paranoid. There really was something strange happening with the HOA enforcement. The next day, I submitted the architectural modification form for my doorbell camera, complete with photographs, specifications, and a note explaining that the device had been installed over a year ago with no previous issues raised. 2 days later, another violation notice arrived. This one cited improper window coverings visible from the street. According to Covenant 10.4c, all window treatments visible from the exterior must be white, off-white, or earth tones. Apparently, the navy blue curtains in my home office violated this provision. The notice stated that I had 7 days to replace the curtains or face a fine of $50 per day until the violation was corrected. I was beyond frustrated. I'd lived in the house for 4 years with the same curtains. Why was this suddenly an issue? More importantly, why was I receiving violation notices for increasingly trivial matters? I decided to do some research. First, I checked Texas property law regarding homeowners associations. I discovered that while HOAs had significant enforcement powers, there were limits to their authority and requirements for how rules could be created and enforced. Then, I read through our HOA's founding documents more carefully, not just the covenants, but the articles of incorporation, bylaws, and amendments. I spent an entire weekend diving into the legal framework that governed our community. What I found surprised me. According to the bylaws, any changes to the enforcement procedures required a community-wide notification at least 30 days prior to implementation. I couldn't recall receiving any such notification about the new enforcement committee or the increased scrutiny. Additionally, the covenants could only be amended with a 2/3 majority vote from all homeowners, not just the board. There was no record of such a vote regarding several of the specific provisions I was being cited for. I decided to reach out to other neighbors to see if they had similar experiences. Julie had given me her contact information, so I texted her to ask if she knew anyone else who might be willing to discuss the HOA situation. She invited me to a small gathering at her house that weekend. Just a few neighbors who are also concerned about what's happening, she explained. When Saturday evening arrived, I walked the 3 blocks to Julie's house. Her home was a well-maintained 2-story colonial with tasteful landscaping, all HOA compliant, I assumed. Inside, I found 5 other homeowners already deep in conversation. Julie introduced me around. There was Martin and his wife Alina from Cedar Street, Thomas from Oakridge Lane, just a few houses down from me, and Sophia from Maple Avenue. "Harrison's been getting the Patricia treatment too," Julie explained as she handed me a beer. "Welcome to the club," Martin said wryly. "What was your offense?" I explained my series of violations: the cacti, the car that wasn't there, the doorbell camera, and now the curtains. "The curtains thing happened to us too," Alina said. "We've had the same burgundy drapes for 5 years, then suddenly they're a violation." "Has anyone challenged these notices?" I asked. Thomas nodded. "I refused to pay a fine for having my garbage can out too long. It was a day I had to leave for work at 5 a.m., so I couldn't possibly have brought it in before the 7 p.m. cutoff. They added late fees and threatened to put a lien on my house." "Did they have the authority to do that?" I asked. "According to the covenants, yes," he sighed. "I ended up paying $175 for a garbage can violation to avoid legal trouble." Sophia, who'd been quietly listening, spoke up. "There's something else going on. My cousin is a real estate agent, and she says Patricia's husband owns a property management company that's trying to get the contract for Oakridge Estates. The more violations they can show our current management company missing, the stronger their case." This information cast the situation in a new light. If true, there was a clear conflict of interest motivating the sudden increase in violations. "Has anyone looked closely at whether all these rules are being properly enforced according to the HOA's legal documents?" I asked. "I spent some time reviewing the bylaws, and I'm not convinced they're following proper procedures." "What do you mean?" Julie asked. "Well, for instance, enforcement changes require community notification. Did anyone receive formal notice about this new enforcement committee?" Everyone shook their heads. "And some of these rules they're citing seem to have been modified without the required homeowner vote," I continued. "You sound like you know something about this stuff," Martin observed. "I'm not a lawyer," I clarified, "but I've done some research. And I think there might be grounds to challenge not just individual violations, but the enforcement process itself." The group seemed energized by this possibility. We agreed to each review our HOA documents and compile a list of violations we'd received. We'd meet again in a week to compare notes and discuss potential action. As I walked home that night, I felt a sense of purpose I hadn't expected. What had started as personal annoyance was evolving into something larger, a genuine concern about abuse of power and proper governance in our community. My research continued throughout the week. I requested meeting minutes from the past year from the management company, citing the homeowner's right to access HOA records. I also began documenting inconsistencies in enforcement, photographing homes with doorbell cameras identical to mine, non-conforming plants, and window coverings in forbidden colors that hadn't received violations. Then, 5 days after our neighborhood meeting, I received the most serious violation notice yet. This one claimed I was operating a business from my home in violation of Covenant 4.2d, which prohibited commercial activities in residential properties. The fine was $100 per day, until the violation was corrected, the basis for this accusation. My employer had allowed me to work remotely 3 days a week after the pandemic, and occasionally clients or colleagues dropped off or picked up documents. According to the violation notice, this constituted business activity. This was absurd. Many people in our neighborhood worked from home at least part-time. There was a clear distinction between running a commercial business and simply doing your job remotely. The covenant was intended to prevent retail operations or high-traffic businesses from operating in residential areas, not to prohibit the modern reality of remote work. I immediately emailed the management company to contest this violation, explaining that I was an employee, not a business owner, and that my work-from-home arrangement created no neighborhood disruption. I also requested the specific evidence they had collected regarding this alleged violation. Their response was infuriating. The Covenant Enforcement Committee has observed multiple non-resident individuals visiting your property during business hours and the exchange of what appears to be business materials. This activity is consistent with commercial operations. They were watching my house and documenting who visited me. The invasion of privacy was stunning. I called Julie immediately. "They're surveilling us," I told her after explaining the latest violation. "They're literally watching my house and documenting who comes and goes." "That's crossing a line," she agreed, sounding alarmed. "Several of us have new violations too. Thomas got one for an unapproved flower type in his garden bed." "We need to accelerate our timeline," I said. "Can we meet tomorrow instead of waiting until the weekend?" The next evening, our group reconvened at Julie's house, now with 3 additional neighbors who'd received similar violations. We compared notes and found a disturbing pattern. The enforcement had ramped up dramatically after Patricia Wilson became president. Violations seemed targeted at certain households while others were ignored, and many of the cited rules either didn't exist in the original covenants or had been modified without proper procedure. "I think we have enough to formally challenge this," I said after reviewing everyone's documentation. "The question is, what's our next step?" "We could hire an attorney," suggested Martin. "That could get expensive," Sophia pointed out. "What about trying to address it internally first?" Asked Julie. "We could request a special meeting with the board and present our findings. Given Patricia's attitude so far, I'm not confident that would work," I replied, "but it's a necessary first step before any legal action." We agreed that I would draft a formal letter to the board requesting a special meeting to address concerns about covenant enforcement. Everyone would sign it to show this wasn't just one disgruntled homeowner. The letter was delivered to each board member's home the next day. It detailed our concerns about procedural irregularities, selective enforcement, and potential conflicts of interest. We requested a meeting within 2 weeks. 3 days later, I received a response not from the board, but from an attorney representing the HOA. The letter stated that our concerns were without merit, and that the board was acting within its authority to enforce the covenants. It warned that continued interference with board operations could result in additional fines. The intimidation tactic only strengthened our resolve. We decided to consult with an attorney of our own. Martin knew a lawyer who specialized in property law and HOA disputes, and we collectively pooled funds to pay for an initial consultation. Jennifer Oakes, the attorney, reviewed our documents and the HOA's response during a Zoom meeting with our core group. "You've actually got a strong case here," she told us after examining everything. "There are several procedural violations in how these rules are being enforced, and the selective enforcement pattern is problematic. Additionally, the conflict of interest with the president's husband's company is significant." "So what do we do?" Julie asked. "First, we send a formal legal response outlining the specific bylaw and covenant violations the board has committed. We request immediate cessation of all fines until proper procedures are followed. Then, we demand access to all board minutes and enforcement records from the past year. Will that stop them from continuing to issue violations? I asked. It might not, Jennifer admitted, but it establishes that you're serious and creates a paper trail for potential further legal action. And if they ignore it, Thomas asked. Then we consider filing for injunctive relief, asking a court to order them to stop enforcement until the procedural issues are resolved. We agreed to proceed with Jennifer's recommendation. She drafted a detailed legal letter citing specific violations of Texas property law and our HOA's governing documents. The letter was delivered to the board and management company via certified mail. The response was swift and unexpected. 2 days after our legal letter was delivered, Patricia Wilson and 2 other board members showed up at my door unannounced. I was working from home that day, which seemed to further fuel their narrative about my business operations. I opened the door cautiously, immediately recognizing Patricia's tight smile. She was accompanied by a man I recognized as the board treasurer and a woman I hadn't seen before. "Mr. Xavier," Patricia began without preamble, "we're here to discuss the inappropriate actions you've been taking against the board." "I'm not sure what you mean by inappropriate," I replied calmly. "Several homeowners have raised legitimate concerns about procedural violations and how the covenants are being enforced. You're undermining the authority of the board and creating discord in the community," she continued. "We're here to offer you a one-time opportunity to withdraw your complaints and pay your outstanding violations before this escalates further." The implicit threat was clear. "I'd be happy to discuss this with you," I said, "but I'm in the middle of a work meeting." "Perhaps we could schedule a time when all concerned homeowners could be present." "This isn't a negotiation," the treasurer interjected. "The violations stand, and the board's authority is clear in the covenants." "Which version of the covenants?" I asked pointedly. "The original ones or the modified ones that weren't properly ratified by homeowner vote as required in Section 15.3 of the bylaws." Patricia's face tightened. "You're making a serious mistake, Mr. Xavier. The board has resources you don't. This won't end well for you." "Are you threatening me, Miss Wilson? Because that would be inappropriate conduct for a board member." The third woman, who had remained silent until now, touched Patricia's arm. "We should go," she said quietly. As they turned to leave, Patricia looked back. "You have until Friday to withdraw your complaint and pay all outstanding fines. After that, we'll pursue all available remedies, including property liens and legal action." I closed the door and immediately called Jennifer Oakes to report the encounter. "This is actually helpful for us," she said after I described the visit. "They've essentially engaged in intimidation, which strengthens our case. Document everything that was said as precisely as you can remember." I wrote down the details of the conversation while they were fresh in my mind, then called Julie and the others to warn them that they might receive similar visits. Sure enough, by that evening, 3 other members of our group had been approached by board members with similar threats. Each time, the board representatives had arrived unannounced and attempted to intimidate the homeowners into backing down. On Friday, instead of capitulating as Patricia had demanded, we filed a formal complaint with the Texas Real Estate Commission, which had oversight authority for HOA management companies. We also scheduled a follow-up consultation with Jennifer to discuss next steps. Over the weekend, something unexpected happened. An unmarked envelope was delivered to my mailbox containing copies of emails between Patricia Wilson and her husband, Marcus Wilson. The emails explicitly discussed using HOA violations to demonstrate the incompetence of the current management company so Marcus's firm could take over the contract. One email from Patricia stated, Target the newer homeowners first. They're less likely to know all the rules or fight back. Xavier on Oakridge Lane is a good start. He travels for work, so he'll likely miss deadlines and incur more fines. Another email discussed the formation of the enforcement committee, which consisted solely of Patricia and two friends who weren't even board members, operating without board approval or proper documentation. Most damning was an email where Patricia instructed someone named Deanne to find anything at the Xavier property we can cite. We need to show more violations in Section 3 to justify the management change. I had no idea who had leaked these emails, but they were exactly what we needed. I immediately forwarded them to Jennifer Oakes and called an emergency meeting with our neighborhood group. When we gathered at Julie's house that evening, the mood was one of shocked vindication. "This is clear evidence of abuse of power," Martin said after reviewing the emails. "And potentially fraud," Jennifer added via speakerphone. "Using HOA authority for personal financial gain is a serious matter." "Who do you think sent these?" Julie wondered. "My guess is someone on the board who's uncomfortable with what's happening," I suggested. The emails were sent to multiple board members. "What do we do with this information?" Thomas asked. Jennifer's advice was clear. "We need to call for an emergency meeting of all homeowners, present the evidence, and demand the removal of the board members involved. At the same time, we should amend our complaint to the Real Estate Commission to include this new evidence." "Will they try to deny the authenticity of the emails?" Sophia asked. "They might," Jennifer acknowledged, "but combined with the pattern of enforcement and the procedural violations we've already documented, it creates a compelling case." We drafted a notice calling for an emergency homeowner meeting, citing the bylaw provision that allowed such meetings when requested by 15% of homeowners. We quickly gathered more than enough signatures from concerned neighbors who had heard about our dispute with the board. The meeting was set for the following Wednesday evening at the community clubhouse. We prepared a detailed presentation outlining our concerns, the evidence of procedural violations, and the damning emails showing abuse of power for personal gain. On Monday, 2 days before the scheduled meeting, I received another violation notice. This one claimed I had made unauthorized statements harmful to the community and threatened a fine of $200 per day for disparagement of the association. The cited covenant was 16.7d, which I couldn't find anywhere in my copy of the documents. I forwarded this latest notice to Jennifer, who confirmed what I suspected. "There is no covenant restricting speech about the HOA. This is a transparent attempt to silence you and is completely unenforceable." When Wednesday evening arrived, the community clubhouse was packed. Nearly half of the neighborhood's 112 homeowners had shown up, an unprecedented turnout for an HOA meeting. Patricia and the other board members sat at their usual table at the front, looking tense. Since we had called the meeting, Julie began by explaining why we were there and outlining our concerns about covenant enforcement. I then took over to present the specific evidence we had gathered. Over the past 2 months, several homeowners have received an unusual number of violation notices for issues that had never been problems before, I explained. We became concerned when we noticed patterns of selective enforcement and procedural irregularities. I detailed the various violations many of us had received and showed photographic evidence of identical situations at other homes that weren't cited. I explained the bylaw provisions requiring notification of enforcement changes that hadn't been followed. Then, I reached the emails. Most concerning is evidence suggesting these violations aren't about community standards at all, but rather about personal financial gain. A murmur ran through the audience as I displayed the emails on the projector screen, with certain sections highlighted. Patricia immediately stood up. "Those are fabricated documents. This is slander, and the association will pursue legal action." "Are you denying that you sent these emails, Miss Wilson?" I asked calmly. "I'm denying the authenticity of whatever you're displaying," she snapped. "Then you won't mind if we subpoena the original emails from your accounts as part of discovery in a legal proceeding?" Jennifer Oakes interjected, standing up from her seat in the audience. "I'm Jennifer Oakes, attorney for these homeowners, and we're prepared to pursue this matter in court if necessary." The room erupted in conversation. Several homeowners stood to share their own experiences with recent violations, creating a clear pattern that aligned with what we had presented. A man I didn't recognize raised his hand and was acknowledged. "I'm Robert Jennings. I've been on the board for 5 years. I have to say, I've been increasingly uncomfortable with the enforcement direction under President Wilson's leadership. The enforcement committee was never properly established by board vote, and I've objected to several of these actions in closed sessions." This statement from a sitting board member created another stir in the room. Patricia's face had turned an alarming shade of red. "This meeting is out of order," she declared, gathering her papers. "We're adjourning until proper notice can be." "Point of order," called another homeowner who identified herself as a former board member. "According to the bylaws, a special meeting called by the required percentage of homeowners cannot be adjourned without a majority vote of those present." "She's correct," Jennifer confirmed. Realizing she couldn't simply shut down the meeting, Patricia and the treasurer attempted to leave. As they stood to go, another board member, the woman who had been with Patricia during her visit to my house, remained seated. "I think we should address these concerns," she said, surprising everyone. "If mistakes have been made, we have a responsibility to correct them." Patricia turned to her in obvious anger. "Deanne, this isn't the time or place." "Deanne," I interrupted. "Are you Deanne Fletcher?" She nodded, looking confused. I highlighted a section from one of the emails. Patricia instructed someone named Deanne to find anything at the Xavier property we can cite. Diane's face fell as she recognized her own involvement. I didn't know about the connection to her husband's company. "She just told me we needed to improve covenant enforcement." The meeting continued for nearly 3 hours. By the end, a vote of no confidence had been passed against Patricia Wilson and the treasurer. 3 other board members, including Deanne, agreed to remain in a caretaker capacity until a special election could be held. All outstanding violation notices were suspended pending review, and a committee was formed to examine the covenant enforcement procedures and recommend changes. Patricia and the treasurer stormed out before the meeting concluded, but not before Patricia pointed at me and declared, "This isn't over, Xavier." She was right, but not in the way she intended. Over the next few weeks, our complaint with the Texas Real Estate Commission led to an investigation of both the HOA board and the potential conflict of interest with Marcus Wilson's management company. The commission found multiple violations of state regulations and issued fines to both Patricia personally and to the HOA. The leaked emails were authenticated when the commission subpoenaed the records, proving that our copies were genuine. This led to Patricia's resignation from the board and the withdrawal of her husband's company from consideration for the management contract. Our attorney helped us draft amendments to the HOA bylaws that created greater transparency in covenant enforcement, including requirements for photographic evidence of violations, an appeals process, and regular rotation of enforcement committee members to prevent selective targeting. 2 months after our confrontation at the emergency meeting, a special election was held to fill the vacant board positions. Julie was elected as the new president, with Thomas and Martin also winning seats. Their first official act was to formally rescind all violation notices issued during Patricia's tenure and establish a committee to review the covenants themselves for clarity and fairness. As for my specific violations, the new board determined that doorbell cameras were reasonable security measures that didn't require special approval. Window coverings were only regulated if they created community eyesores, which my navy curtains certainly did not. And remote work that didn't create traffic or noise issues was not a violation of the business activity covenant. The cacti, however, technically remained non-compliant with the approved plant list. But rather than force their removal, the board expanded the approved vegetation list to include drought-resistant plants, acknowledging the changing climate conditions in Texas and the need for water conservation. The final chapter in this saga came 6 months later, when local news broke that Patricia and Marcus Wilson were under investigation for similar schemes in 3 other communities, where she had served on HOA boards, and he had subsequently secured management contracts. The story specifically cited our neighborhood's successful challenge as having brought the pattern to light. On a warm Saturday in October, our neighborhood held its first ever community picnic, an event that would have been impossible under the previous regime due to restrictions on unapproved gatherings. As I helped set up tables in the common area, Julie approached with a smile. "Have you seen the latest?" she asked, showing me her phone. It was a news update reporting that Patricia and Marcus Wilson had been charged with multiple counts of fraud and corruption related to their HOA schemes. "Justice moves slowly, but it does move," I remarked. "None of this would have happened if you hadn't stood your ground on those cacti," Julie pointed out. "Sometimes the smallest things lead to the biggest changes." She was right. My simple refusal to accept unfair treatment had uncovered a significant abuse of power that affected dozens of families. By questioning rules that didn't make sense and insisting on proper procedures, we had transformed our community from one ruled by fear and arbitrary enforcement to one governed by transparency and fairness. As neighbors gathered for the picnic, there was a palpable sense of community that had been missing before. Children played freely on the grass without parents worrying about violation notices for unauthorized recreational activities. Homeowners chatted about improvement projects they were planning now that the approval process had been streamlined and clarified. Thomas approached with his wife, carrying a housewarming gift, a small potted cactus. "Thought you might want to put this on your front porch," he said with a grin. "A symbol of resistance." I laughed and accepted it gratefully. "I think I will, and this time I'm certain it complies with all applicable regulations." Later that evening, as the picnic wound down and neighbors helped clean up, I reflected on the journey of the past year. What had started as a simple dispute over 3 potted plants had evolved into a complete reformation of our community governance. It had required courage, persistence, and collective action, but the results were worth every moment of struggle. I placed the new cactus prominently on my front porch that night, no longer as an act of defiance, but as a reminder that when rules are arbitrary, unfair, or improperly enforced, standing up for what's right isn't just an option. It's a responsibility. The HOA still existed, and we still had rules, necessary ones that protected property values and community standards. But now those rules were fairly created, clearly communicated, and equitably enforced. We had transformed a tool of oppression into what it was always meant to be: a framework for cooperative living that respected individual rights while maintaining community standards. As I watched the sunset from my porch, navy blue curtains visible through my windows and cacti proudly displayed, I felt a deep satisfaction. Sometimes fighting the system isn't about destroying it, it's about making it work the way it should have all along.